how his statement was taken. DSP, can you hear me?
I can hear you. Yes, ma'am.
Okay, please proceed. Tell this honorable court the circumstances under which his statement was taken.
Yes, madam. The defendant, when he was brought to the office, I read the cautionary word to him, to his understanding. Shall I continue?
Yes, continue.
I read the word of caution to him where he understood, and he volunteered to write his own statement.
Prosecuting counsel?
Yes, my lord.
I was offline for a few seconds.
Okay, my lord.
So let him just repeat everything.
Okay, my lord.
Yes.
We are saying.
So I want you to tell this honorable court the circumstances under which he volunteered his statement.
Yes, my lord. When the defendant was brought to the office by the military and handed over to us.
Just a minute, I'm writing.
Yes, my lord.
Yes.
I read over the word of caution to him, my lord. Where he understood and opted to write his own statement by himself. And after writing, he appended his signature to the statement, my lord. The defendant confessed to committing the crime. And the confessional statement form was brought to me, being the most senior officer.
You see it, the confessional statement?
Yes, my lord, the attestation form was brought to me as the senior officer, and I also signed.
Yes.
That's it, my lord.
Yes, go on. I want you to tell this court step by step the way in which the statement was taken. Who was it taken before? The members of your team, if you were in a team. I want you to tell this honorable court.
Yes, ma'am. After reading the first...
Just a minute. Is the defendant counsel there?
My lord, I'm around, but I'm objecting to the line of questioning. She's not to lead the witness. She's not to lead the examination in chief. So she's allowed the witness statement, not that
Counsel, you need to talk to me so that I can understand you. You keep moving about. I can barely hear you.
My lord has
The
and he said that's all. So I am objecting to a question as a leading question to the witness. Yeah, my lord.
yes,
I used to.
My lord, I am objecting.
You said you're objecting. I've heard your objection.
Yes, my lord. The objection is on the basis that
I'm having so much challenges hearing this particular counsel. I do not know whether the gadget is using, the volume is very low. I'm not sure. I can hear everybody clearly except that particular counsel. The gadget you're using, is it the volume, is it low? Why can't you check? Defendant's counsel. Defense counsel. Or can he change the gadget and use one other? Because it's very...
You can proceed in order not to waste the time of the honorable court.
Okay, now we heard you. Sometimes you're audible, sometimes you are not.
That is the network.
Yes, but I can hear you clearly now. You said you're objecting because it was a leading question.
That is to allow the witness to state what role he played in recording the statement of the accused. That's all.
My lord, can I respond?
Just a minute. I'm trying to record what you say.
Okay, my lord. Thank you.
You're welcome. Yes, you can respond. Counsel, go ahead. Prosecuting counsel.
My lord, the examination question does not require a yes or no. The question I asked is not a leading question, my lord.
Yes. Prosecuting counsel, are you through?
Yes, my lord. My lord, I said the questions I asked are not leading in nature. They are all questions no answer, and I believe examination in chief, my lord.
In the process, ruling. Are you all there?
Yes, my
Yes,
lord.
my lord.
In the process of examination in chief, the prosecuting counsel asked the witness to tell the court step by step the role he played, to which the defense counsel challenged same on the ground that it's a leading question. This honorable court, having listened to both counsel in their arguments, hereby overrules the defense counsel as no leading question has been asked. The witness may continue.
The court pleases. DSP, I want you to take it step by step. How was the statement taken? Tell the court the general condition of the defendant, the members of the that were present, those that were present while the statement was being written. I want you to take it step by step, please. And the court is recording.
Noted, my lord. The suspect was brought in by the military in a very good health condition. After the handing and taking over,
yes,
I read the word of caution to the understanding of the suspect then, my lord.
continue.
Having understood the word of caution, the suspect chose to write his own statement. Without any use of threats, enticement, or inducement, or promise of whatsoever, the suspect confessed to have committed the crime. The statement was recorded in the presence of my team, who include ASP Innocent Okori.
Just a minute.
Yes, my lord.
Yes.
Team members include ASP Innocent Okori, ASP Ibrahim Abdul, Inspector Zainab Wakili.
Yes.
After writing his statement, my lord, ASP Ibrahim Abdul read over the statement to him again.
Yes.
And the suspect admitted he was his own, and he also appended his signature to it. The
Yes.
attestation form was brought to me as a senior officer, and I signed. Let me finally reiterate, my lord, there was no threat, no inducement, no promise whatsoever was made to the suspect.
No threat, no inducement.
No promise whatsoever nature was made to the suspect.
Yes.
That's it, my lord. Thank you, my lord.
Yes.
Is there any other thing you want to add to what you have just said?
No, so far, nothing.
My lord, that is all for the witness.
Any cross-examination?
Yes, my lord.
Yes, go ahead.
Mr. Maji Abdul,
Yes,
you will be surprised if OJ will come and testify before the honorable court that you threaten him and you promise him.
Counsel, we can't hear. Will he be surprised that?
You will be surprised that if OJ should testify to the effect that there was threat, inducement, and promise.
yes, I will definitely be surprised, my lord.
When you confess committing the offense,
Just, you need to ask the question. Give me time to record before you answer.
Noted, my lord.
So, Mr. Maji, will you be surprised if OJ, the defendant, will testify to the effect that there was threat, inducement, and promise?
Yes. Yes, the witness, can you answer?
Yes, my lord, I will be surprised and shocked because nothing of such nature took place.
Yes. Yes.
You recruit the accused person, the defendant made his statement on the 10th of August 2021. Mr. Aji, Mr. Maji.
Sir, my lord.
Defendant statement was recorded on the 10th of August 2021.
I'm sorry, the question is not well clear, sorry.
You cautioned the accused person, the defendant, on the 10th August 2021. Is that so?
I can't remember the precise date, sorry.
Counsel.
What the attestment? You endorsed the attestment form when?
Sorry, my lord, I can't recall the date.
Yes.
Sorry, my lord. That's all the details.
Mr. Auta is still there?
My lord, I say that is all for the witness, my lord.
Oh, I see. Okay. Any re-examination?
No re-examination, my lord.
Yes.
And we humbly apply that the witness be discharged, my lord.
Application granted. Thank you, officer.
Thank you, my lord. Thank you.
My lord, that is all for the trial within trial. We are closing our case in trial within trial, my lord.
Yes.
Or the defendant come and give evidence that within trial.
Counsel, I didn't hear that.
My lord, we are applying for adjournment for a date for the defendant to come and give evidence in the trial within trial. So subject to the Honorable Court convenience, any date convenient, my lord.
Can you give us a date? Registry of court? When? How many cases do we have on that date? Is the person being brought from the correctional center? Okay. 28th of November. Okay.
28th November is convenient.
Prosecuting counsel? Prosecuting counsel?
My lord, I
28th
didn't
day
quite
of
get the
November.
date, my lord.
28th day of November.
It is convenient, my lord.
Is the prosecuting counsel from the NDLEA here? I've not seen him online.
Yes, my lord. I'm here, my lord.
Okay.
With your kind permission, my lord, we'll take
No, just a minute. Counsel. Okay. I need to print out the proceedings and then a ruling. This case was called. Defendants in court. This matter is hereby adjourned on the concurrence of counsel to the 20th day of November 2023 for defense. A defendant is to be remanded at the Potiskum Correctional Center to the next adjourned date. Yes, call the next case.
We are grateful, madam.
You're
Thank
welcome.
Charge number FSC/DM/CR/31/2023 between Federal Republic of Nigeria and Aminu.
My Lord, we are here at the correction center together with the defendant, Aminu, present, my Lord.
Thank you.
Thank you, my Lord.
With the greatest respect and much honor, my Lord, my name is Usman Bamala. My humble appearance is for the complainant.
To respect and humility to my Lord, my name is Yuel Lukman, and my appearance is for the defendant, my Lord.
My Lord, the matter is fixed today for sentence and subject to the convenience of my Lord, we are ready.
Sentence.
As God please, my Lord.
On the 19th day of July 2023, the convict Aminu hearing was adjudged guilty of the indictment in the charge sheet dated 17 July 2023 and filed 18 July 2023 based on a plea of guilty, which he entered when he was arraigned before this court on 19th day of July 2023. The sentencing do you think you'll be able to interpret to him? Correctional Center?
My Lord, I got split, my Lord.
The sentencing was deferred till today to enable me have a deeper reflection on the appropriate sentence, which will meet the justice of his case. In criminal jurisprudence, the two broad goals of judicial sentencing are, firstly, to seek the reform of the convict so that by the time he completes the penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land.
Wannan hukunci da rubuta ka ana son ka koma cikin al'umma kasance mutum mai nagarta, mutum nagari wanda zaka amfani al'umma da ƙasa baki daya.
The second goal is to impose such sentence as will serve as deterrence to other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished.
Saboda haka ko da ma wani ne ka gani a waje, misali bayan ka fita, zai yi irin wani abu da ka aikata wanda aka hukunta ka kai ma mai ba da shawari ne akan kar ya aikata saboda irin abin da ka yi ba mai kyau ba.
While the first goal focuses on the convicts in the dock, the second goal, in my view, focuses both on the convicts in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced.
Kuma bayan koda kasancewar in ka gama ka fita, da Allah ya kasance mai ba da koda shawari a wasu ne kasancewar kasu ka aikata irin laifin da ka aikata wani.
In relation to the convict, the sentence will impose is to, the sentence the court will impose is to be such as will deter him or her from going back into the same or similar activity as constituted the offense for which he is being punished, whilst for the other persons out there who are yet to be caught in the web of the law, to persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity. These goals are no doubt largely sociological in nature.
Okay. Kuma ko da kasancewar ka abu nan ka zama ka yi free da wannan ɗin mutane, wasu wanda ke da ko da niyya ma na aikata irin naka ɗin, kai ma mai ba da shawari na kan cewa wannan abu laifi ne wanda ga irin yadda sakamakon sa yake, don haka sai kana ba da shawara.
In striving to attain both goals, which are really not mutually exclusive, it is the desire of every court of law to strike a delicate balance in order to ensure that the attainment of one goal does not ultimately and invariably lead to the defeat or frustration of the other. In its efforts to achieve this, the court takes into consideration a number of factors, and the court, in being able to do this, is required as a baseline to be able to locate the station in life of the convict. By this, the court takes into consideration the attitude of the convict upon his arraignment on the indictment, where a defendant who truly believes and accepts that he was guilty of the allegation in the indictment and readily pleaded guilty to, upon his arraignment in court, it is part of the factors, as in this instance, which the court is required to take into consideration when imposing a sentence.
Kotu ta yi dubi da cewa ka amsa tuhumar da aka maka da ka amsa a kai yanzu, ga shi yanzu kuma za a hukunta ka a kai, ko da kasancewar dai ka fita duk da shawari ne akan kasancewa.
Quite often, except there are other overriding considerations or extenuating issues, such a convict will be given a discount in terms of his or her sentence. The court is also required, especially in cases involving trafficking in narcotics, to take into consideration the nature of the drugs involved. In this case, it was cannabis sativa that the defendant was convicted of being in unlawful possession with. The provisions of the NDLEA Act stipulates different regimes of punishment for unlawful possession of cannabis sativa, in contrast with such other hard drugs and psychotropic substances such as cocaine or heroin. The court in such cases will consider the quantity found in possession of the defendant when arrested. This enables the court to ascertain whether the defendant is a mere user or abuser of hard drugs, or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant has done to himself as a consumer or to the society as a retail or commercial dealer of illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration, because the court will frown at a defendant who attempts to transport hard drugs, example, cannabis sativa, cocaine or heroin or controlled drugs from state to state, as much as one who is selling it in a marketplace or renting a shop and clandestinely in the guise of selling provisions, selling illicit substances. In view of the fact that in either of these two scenarios, the society is at the receiving end, therefore the court will not likely be lenient with such defendants. The court, in relation to a defendant who attempts to transport either hard drugs or controlled drugs, will also be concerned with the mode of concealment. This enables the court to assess the defendant as either an incorrigible dealer or trafficker or a novice who has only been introduced into the illicit business. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station in life of the convicts in order to impose such punishment as will meet the justice of the case.
Hukuma ta tanadi, an tanadi hukuma ta hana duk wannan mu'amala da harkokin ƙwayoyi masu haukatarwa da kuma sauran laifuka irin na wannan harka sai da ƙwayar ko sha ko mu'amala da ita duka. Saboda haka duk wanda aka same shi da irin wannan laifin dole ne za a hukunta shi, shine ka'idar.
This is the reason why in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convict, and which may invariably impair the attainment of even the goal. The attainment of the goal to seek the reform of the convict, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convict and the larger society. Where the sentence is comparatively too harsh and out of tune with the realities of the convict station in life, such excessive punishment may eventually well up in the convict a spirit and attitude of indignation, and he will see both the state and its laws as rather too unjust. Such a harsh punishment may never appeal to a spirit of remorse or of contrition, as such a convict will bear an unforgivable grudge against both the state, its laws, and its people, and will seek to revenge even after he may have served out the harsh punishment unjustly imposed. On the contrary, where the sentence is too light, the convict takes it as a slap on the wrist, and such comical sentence will never encourage the convict to turn over to a new leaf and be reformed. In view of the fact that trafficking in illicit drugs has been adjudged as a transnational organized economic crime, such a convict, once he has finished his sentence, will readily go back to the same illicit sentence, to the same illicit business, in the hope that even if he is caught, it's a question of a few months incarceration, and he will be released to return to the business and make good money in illicit traffic in hard drugs. A sentence that is comparatively too light will also not serve as a deterrence to the individuals who are involved in similar activities, or deter those who are already contemplating getting involved or being groomed by the drug laws to be used as traffickers for a commission as fees. It is obvious when this occurs, the court has not discharged its statutory duty well in ensuring that the sentence is one which strikes the delicate balance, which I've briefly analyzed and which are essentially sociological in nature. In my efforts to do this, I took the opportunity to read the extrajudicial statement made by the convict, which was in the court file pursuant to Section 122 Evidence Act 2011. When I read the convict statement, I have the impression of an unmarried man of 25 years who has really not been fully engaged in any productive venture. In his extrajudicial statement, the convict stated that he was arrested on the 15th day of July 2023 at the NDLEA Stop and Search Operation Patrol Point along Kanunguru Road, Yobe State, with blocks of dried weeds concealed inside sacks. He also stated in his own words, "I'm not doing any business rather than studying Quran. I was introduced into carrying dried weed by Modu, also known as Kango, who is coming from Buliagif of Kanama of Yobe State at Gedam Goat Market. This is the second time during first time my master Madu, known as Kango, paid me the sum of 40,000 Naira for my commission. Suddenly today, being 15th July 2023, about 7 o'clock, I was on my way from Kano to Gaidam. On reaching Nguru NDLEA officers stopped our Red Sharon car and demanded to search the car. In the process of searching, they discovered a black bag, a black sack, and the officers asked who the owner of this bag, and I answered and said, "It's my bag," and gave them to search. In the course of searching, they discovered Wiwi. Then I was arrested and taken to their office. The recovered exhibit was counted 70 blocks and weighed in my presence, and it was tested and proved positive for cannabis sativa. This same, what was stated in the statement, he also stated it in court when he was asked. When I read the case file and the statements volunteered by the convicts, I'm left with the impression in this illicit trade, he's not such a novice. As he stated above, this is his second time in transporting such a huge amount of illicit compressed dried weed, even though the prosecution had no previous record of his involvement in this type of crime prior to when he was arrested in July 2023. By the provision of Section 19 of the NDLEA Act, Supra, the maximum punishment prescribed by law upon conviction is to be sentenced to imprisonment for a term not less than 15 years and not exceeding 25 years. However, having regard to the considerations which had analyzed the fact that the convicts readily pleaded guilty to the charge immediately upon his arraignment on the 19th day of July 2023, and of the fact that he appears remorseful, are factors which ought to inform the sentence which this court will pass. Although the quantity of the hard drugs, dried meats recovered from his possession was 70 kilograms, which betrayed him as a commercial dealer, I believe his story that he has been at this nefarious act for the second time transporting same before his arrest. Although this was the first time he has been arrested. Even though the convicts mentioned one Madu, aka Kango, who supplies the evil consignment, that is Exhibit 2 for the convict to transport same, the NDLEA in court assured the court that it will go after the said Madu, aka Kango, so that he can be apprehended and possibly charged to court. The investigation often conducted by the NDLEA is, in my view, rather too tardy and superficial. And this may be the reason why, despite the incredibly huge convictions which we have judicially recorded, the country's judicial legal systems do not seem to be winning the war against this illicit narcotic trade. The big barons are left untouched, and the court is only being asked to try and convict their errand boys, who are foot soldiers. There are too many loose ends and loopholes in the investigation being conducted by the NDLEA, and it is time it buckle up. Otherwise, all we do here is to hear cases and nothing more than a sheer waste of judicial time and of scarce state resources. in the final analysis. The convict is hereby sentenced to 3 years imprisonment for the first count, 3 years imprisonment for the second count, and 3 years imprisonment for the third count, or the conviction to go concurrently. The sentence shall be deemed to have commenced from the 15th day of July 2023, when he was arrested by a team of NDLEA officers at a stop and search operations patrol point along Kanonguru Road, Yobe State. The seized drugs being cannabis sativa admitted as exhibit NDLEA Mamman 2, and which weighs 70 kilograms, is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit NDLEA Mamman 2 shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Service, and the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convicts, which I deferred to today in order to reflect deeply on the appropriate sentence. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family. The convict may not be so lucky if in the future he is caught and charged for a similar offense. This shall be the court sentence.
Tuhuma biyu da aka same ka da laifuka. Kotu ta hukunta ka da ɗauri na shekara 3, tuhuma ta farko. Tuhuma ta biyu ma kotu ta ɗaure ka da shekara 3, dukansu shekara 3 kenan. Amma zai fara daga ranar da aka kama ka gaba ɗaya. Kuma ana so in kai wannan zama a wannan hukuncin an yi shi cikin abubuwa cikin sassauci ne. Kuma ana so in Allah ya sa ka yi wannan zaman kwanakin da aka yanka, in ka fita ka kasance mutum na gari mai gyara a al'amuransa ba kuma wanda zai ƙara kasancewa mai laifi ba. Thank you, my lord.
Thank you. The sentencing will run concurrently.
Thank you, my lord. Kuma hukuncin ya kasance ne zai fara shekara 3 ne duka.
Call the next case.
We are grateful, my lord. Thank you, my lord.
Thank you so much.
Charge number FSC/DM/CR/30/2023 between Federal Republic of Nigeria and Omar Ahmed, aka Bali.
Umar Ahmed.
Let him sit if he's ill.
My lord, here at the Defender and Correction Center, but he's not well, my lord.
Yes, let him sit. Let him, get him a chair, let him sit.
Okay.
Representation, please.
With the greatest respect and much honor, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
No representation?
Yes, my lord.
My lord, the matter is fixed today for review of fact, my lord. And subject to the convenience of my lord, we are ready to proceed. My lord, the complainant intends to review the fact of this case through the exhibit officer in person of Mr. Muhammad Gaju Suleiman. My lord, we apply Mr. Gaju Muhammad Suleiman to step forth.
My lord. Yeah, at Mohammed Raji.
Can you affirm yourself? Then
Yes.
Let me affirm myself before. I, Salisu Isa, do solemnly interpret court proceedings from English to Hausa language and vice versa to the best of my ability, so help me God.
I, Sulaiman Mohammed Rabi, do solemnly affirm to state that the evidence I shall give in this case before this honorable court shall be the truth, nothing but the whole truth, so help me God.
Wannan shine sai da zai bayar akan abin da ake tuhuma.
yes.
Once again, tell this honorable court your name. My name is Sulaiman Mohammed Rabi.
Sunansa Muhammad Sulaiman.
Rabi Sulaiman, what do you do for a living? I work with the National Drug Law Enforcement Agency of State Command. For how long have you been working with the agency? For 3 years. So far, what rank did you attain? Chief Narcotic Agent. As a Chief Narcotic Agent, I believe you are professional in your doing. Yes, my lord. Please tell this honorable court, what are your schedules of duty for all these 3 years as an exhibit officer? Okay, my lord.
You are the exhibit officer? Can you hear me?
Yes, my lord.
Yes, because you didn't say that. Yes, go ahead.
Okay. Receiving of suspect and the exhibit recovered from them.
Go ahead, continue.
Okay, carrying out a field test on the exhibit recovered from the suspect, weighing of the exhibit, issuing of exhibit forms, namely certificate of test analysis, request for scientific aid form, packaging of substance form, keeping an entry of the bulk of the exhibit in an exhibit room for safekeeping, taking a sample of exhibit A1 to Lagos for scientific analysis, testifying and giving evidence in court regard to the exhibit handled by me or kept by my custody, and any other given to me by my commanding officer.
Can you interpret, Mr. Salihu?
Yes, my lord. Shine bincike akan kayayyaki da aka kawo, sannan kuma ya ɗauka a tura ne ga wajen ƙwararru su ƙara gudanar da bincike a kai, sannan kuma yana ba da shaida a gaban kotu kamar yanzu haka yadda yake ba shi.
Yes.
Mr. Rabi Suleiman, tell this honorable court what do you know about the defendant in this case? Okay, bearing in mind the court is recording you, please to take a good look at the beginning of the court and ensure that whatever you say, the court have recorded you promptly. Thank you. Yes, on the 16th day of July 2023,
yes,
the defendant was brought before me by Rabiu Ibrahim Haruna, SN. And Ibrahim Ali, CNA. Along with a black polythene bag. I asked the defendant who owns this polyethylene bag and the defendant said that the bag belongs to him. I opened the black polyethylene bag and discovered that there is 2 blocks of compressed dried leaves suspected to be cannabis sativa.
Yes.
I then informed the defendant that I want to carry out a field test on this recovered substance, and he gave me go ahead. After carrying out the test proved positive for cannabis sativa, and the 2 blocks of compressed dried leaves was equally weighed and found to be 2 kilograms. I issued some exhibit forms, namely certificate of test analysis, packaging of substance form, request for scientific aid forms.
Joseph, okay. Can you interpret?
Yes, my lord. Yes, ya same ka da block view na busheshen ganyen da ake zargi ta baro. Sannan bayan ya same ka da wannan, shi da aka je ofisin su an ɗauki kaɗan daga ciki an kai an je an bincika a wajen ƙwararru sun kawo sakamako na cewa wannan busheshen ganye shi ne ta baro ne, kamar yadda yanzu ake gabatarwa haka. Passport please, my lord.
Yes, some exhibit forms were issued.
Yes, namely certificate of test analysis, packaging of substance form, and request for scientific aid form.
Yes, go ahead.
I filled the necessary columns. Witnessing and arresting officer also signed their own column, and the defendant thumbprint on the forms.
Yes.
I took some part of the dry weight and seal it in a white evidence transparent pouch.
Go ahead, we are waiting for you.
Yes, which will later be taken to Lagos for scientific analysis, and the bulk of the exhibit kept in an exhibit room for safekeeping. That's all, my lord.
Can you interpret?
Yes, my lord. Passport please. Yes, akwai wasu forms da aka bayar, forms nasu wanda aka cika su ne sakamakon gwajin a cikin wannan form ake kawowa. Kamar yadda ce ma ana kaiwa a je a ƙwararru su gudanar da bincike. To wannan form din an kawo gashi nan wanda aka gabatar da shi a gaban kotu wanda har aka yi sa hannu aka yi dangwala duka a jiki.
Mr. Mohammed Rabi Suleiman, in the course of your examination in chief, you made mention before this honorable court that you filled some exhibit forms.
Yes, sir.
And in which the defendant equally affixed his thumbprint on it.
Yes,
and you also made mention before this honorable court that you kept the bulk of the exhibit.
Yes, my lord.
In custody for safekeeping.
Yes,
can you be able to tell this honorable court what are the identification you affix on the said forms as well as the bulk of exhibits?
Okay, my lord. On the exhibit forms, my name is written there, date of documentation, my signature. While on the bulk of the exhibit, the name of the defendant was written there, NDLA case file number, and date of documentation was also written there.
Thank you very much. My lord, we apply to present through the exhibit officer the said scientific document, which include the packing of the substance from scientific test analysis and the request for scientific aid form, together with the bulk of exhibit, my lord, for identification of court, my lord.
Application granted.
As court,
Please go.
interpret to him.
Okay. Wannan su ne forms ɗin da ya faɗa. Sannan kuma wannan shine ainihin word ɗin abin da aka saba wajen na kamar da na gaya maka. Ga wannan forms ɗin na sakamakon.
Malak, these are the forms. Like I stated earlier, my name is written there, my signature, date of documentation.
Can you put it on the table?
Okay. My lord, these are the two blocks, but they were affected by rodents.
My lord.
Yes.
My lord, the circumstances haven't identified the said exhibit forms and the bulk of exhibit. My lord, we sought to tender the portion of the substance from scientific test analysis, because for scientific aid, certificate of test analysis, together with the bulk of exhibit in evidence before this honorable court.
The exhibit officer, the witness, and anything written on it, on the exhibit?
Yes, my lord.
Yes.
NDLEA stroke YBSC.
Go ahead.
Stroke 027, stroke 2023.
The exhibit is wrapped in brown paper.
No, my lord. In yellow and black sellotape.
Yellow and black
sellotape.
Can you interpret and show him?
Wannan su ne ainihin abin da aka samu a wajen naka.
You are not to tell him like that. You are to ask him. Nobody asked him.
Su ne da aka samu a wajen ka? Malati says,
Kwarai kuwa. Na neman alfarma ne kawai.
No extrajudicial statements of the defendant?
Yes, we do not intend to tender the extrajudicial statement of the defendant, my lord.
Okay.
My lord, that's all for the...
Just a minute. The following exhibits are hereby admitted into evidence as the exhibit forms comprising of certificate of test analysis form, packing of substance form, request for scientific aid form, hereby marked as NDLEA Umar 1A, 1B, and 1C respectively. The bulk of the exhibit of 2 block compressed dried wheat wrapped in yellow and black sellotape in some loose quantity with the inscription NDLEA-YBSC 027-2023, marked as NDLEA Umaru 2.
My Lord,
yes.
That's all for the examination, Chief.
Ask the defendant if he has any questions to ask the exhibit officer, the witness, before the court.
As God please, my Lord. Ko akwai wata tambaya da zaka yi a shi wannan wanda ya bada sai da akan ka, akwai wata tambaya da zaka yi?
Haka ne.
Ka daga muryanka.
Duk abin da ya fara haka ne, ina neman alfarma ne kawai.
You have shown him the exhibits earlier. Were they the ones recovered from him?
Hello? I saw him before, my Lord.
Yes. He said they are the ones that belong to him. I think I recorded that earlier.
Yes, my Lord.
Yes. Any application made by the prosecuting counsel?
My Lord, we apply for the witness to be discharged as a witness in this matter, my Lord.
Application granted. Thank you, officer.
Thank you, my Lord.
My Lord, and that's all we have for the review of facts of this case, my Lord. We urge this honorable court to convict the defendant as charged.
Can you ask the defendant whether the facts as stated by the prosecution and the exhibits as presented by the exhibit keeper reflect the true position of the case? Interpreter.
My Lord.
Can you ask the defendant whether all the facts as presented by the prosecution counsel and the exhibits as presented by the exhibit keeper reflect the true position of the case?
Wayannan abin da aka gabatar yanzu a gaban da kuma duk dai abin da aka gabatar a gaban shari'a yanzu, ko ka wannan da su duka gaba ki ka aminta da duka daga wannan. Yes, my Lord.
Whether the defendant has any cause to show why he should not be convicted as charged?
Kuma ko kana da wani abin da aka gabatar a gaban kotu wanda ya sa ba da a hukunta ka ba?
He will be given time for allocations because he said I want him to tell the court whether he should not be convicted on the charge before the court.
Akwai wani dalili da ya sa ba za a hukunta ka? My Lord.
The defendant who indicated that he was not literate in English language had the charge filed, interpreted to him through a sworn interpreter. He pleaded guilty to the counts in the state charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of his charge. This was an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove the allegation in a criminal charge which the defendant had voluntarily pleaded guilty to by the provision of the law, except in capital offenses. Once a defendant has pleaded guilty to an indictable felony punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by Section 33, Sub 2 of its Enabling Act, Cap F12 Laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict, to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charge was consequently done. I've listened to the learned prosecutor, Usman Bamala, who has produced certain documentary and real exhibits which have been admitted in evidence. Exhibit Umar 2 being the bulk of exhibits seized and recovered from the defendant in the course of operations by NDLA officers is cannabis sativa. It is one of the hard drugs which the extant legislation, that is the National Drug Law Enforcement Agency ADCAP M30 laws of the Federation of Nigeria 2004, has outrightly, except where lawful authority shown prohibited its sole possession and or consumption. The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of Exhibit Umaru 2. I'm satisfied against his plea of guilty that this case has been proved against the defendant beyond reasonable doubt, as is required by Section 137 and 138 of the Evidence Act 2011. In view of the plea of guilt entered by the defendant and in line with the provisions of Sections 2741 and 2 and 3561 and 2 of the Administration of Criminal Justice Act, this court hereby find the defendant, Umaru Ahmadu, aka Bale, guilty of knowingly, without lawful authority, found in possession and was arrested dealing in 2 kilograms of dried weed substance, a narcotic drug similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 and 14 of the NDLEA Act Cap M30 laws of the Federation of Nigeria 2004. The defendant, Umaru Ahmadu, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convict before I pronounce on the sentence. This shall be the judgment of this court on the basis of the charge dated 16th July 2023 and filed on the 16th July 2023. Any record of previous conviction?
That's okay. My lord, the convict has no previous record of conviction. And my lord, the convict did not interrupt the investigation of this case. Likewise, he did not offer this honorable court to undergo a rigorous trial. And more so considering the physical challenge of the convict, my lord, I know from my own personal knowledge, and the court will also take judicial notice of that, from the date of his arraignment. My lord, he was arraigned very strong. He can stand on his feet, my lord. My lord, however, my lord, the nature has changed the destiny, my lord. My lord, we urge this honorable court to consider that, my lord, as mitigating factor. My lord, that's all I can say. Thank you very much.
Can you interpret? You're just standing there. You need to interpret. I need not prompt you every now and then to interpret.
Okay. Yawwa, kana ji ba? Kotu ne take ta tambayi shi lauya mai gabatar da ƙara. Ko ka taɓa aikata laifi kamar na hukunta ka? Ya ce baka taɓa aikata. Abin da ya tambayi kotu kenan. Kotu ta tambaye shi kuma ya ansa. Sai baka taɓa aikata makamancin irin wannan ba.
Let him address the court. Does he have anything to say?
Akwai wani abu da zaka gaya wa kotu ne kai din?
I cannot hear him.
Alfarma kawai kotu ta mu. Saboda ba lafiya ina ta kaina ne.
The exhibits found in your possession, what were you doing with them? Do you smoke or sell them?
Me kake yi da shi wannan abin da aka samu wajen naka? Sayarwa kake ko sha kai?
Shi ma an kama ni ne na sayarwa ne, amma ba na hawa bane, amma a hannu aka kama ni. Aka zo da nawa.
It is for sale, but it's not yours.
Sayarwa ne kake yi?
It is for sale, but it's not yours. Was that what he said?
Kana sayarwa ne amma baka amfani da shi.
I said, he said it is for sale, but it's not his own.
Kana sayarwa ne amma ba naka bane.
Ba nawa bane.
I did not hear that.
He said he is not the owner, but he sells for somebody. That is it.
He sells for somebody.
Yes, that is the song. That's it.
Sentence.
As God please, my Lord.
On the 19th day of July 2023, the convict Umaru Amadu, aka Bale, hearing was adjudged guilty of the indictment in a 2-count charge dated 17th July and filed on the 18th July 2023 based on a plea of guilty which he entered when he was arraigned before the court on the 19th day of July 2023. That the defendant on the 16th day of July 2023 at the course of raid operations at Sunday Market area Damaturu by NDLA officers without lawful authority was found and arrested in possession and also dealing in 2 kilograms of dried weed suspected to be cannabis sativa, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the National Drug Law Enforcement Agency Act, Cap 30 laws of the Federation of Nigeria. The convict pleaded guilty to the 2 counts, and the learned prosecutor applied for a summary trial, which the court obliged today in line with Section 274 sub 1 and 2 and Section 375 of the Administration of Criminal Justice Act 2015, in passing sentence on the convict, that the convict pleaded guilty to the charge on false arraignment and of the fact that he appears remorseful and also sick, ill. I also take into consideration the plea mitigation made by the convict, as well as the prosecuting counsel for the court to temper justice with mercy. This court has taken into consideration that the convict is a first-time offender before this court, but the court is also required, especially in cases involving illicit dealing in narcotics, to take into consideration the nature of the drugs involved. In this case, I have to consider the amount of the Indian hemp found with the convict and the adverse effect on his family and the colossal damage it causes the society. Therefore, there's a need to give a deterrent sentence to send the message that such acts are not acceptable. Again, the location of the arrest of the defendant is an important consideration because the court will frown at a defendant who attempts to transport hard drugs, example, cannabis, sativa, or controlled drugs from state to state, as much as one who is selling in an open marketplace, in view of the fact that in either of these two scenarios, the society is at the receiving end. Therefore, the court will not likely be lenient with such defenders. I took the opportunity. Anyway, go ahead.
Kotu ta yi la'akari da ba a taɓa samun ka da laifi ba, kuma sannan an gabatar da kotu da.
I take the opportunity to read the extrajudicial statement made. Pottiscombe Correctional Center, are you still with us? Pottiscombe Correctional Center?
My lord, we are hearing you very well, my lord.
Okay, I took the opportunity to read the extrajudicial statement made by the convict, which was in the court file, portion to Section 122 Evidence Act. When I read the convict statement, I have the impression of an unmarried man of 25 years who has really not been fully engaged in any productive venture. In his extrajudicial statement, the convict stated that he was arrested at Travelers Area, Pottiscombe, Yobe State, at the course of patrol operation by the Hunters Association, and was found and arrested in possession of 800 grams. I mean, in possession of 2 grams.
2 kilograms, my lord.
2 kilograms, sorry, 2 kilograms of dried weed suspected to be cannabis sativa, and thereby committed an offense contrary to and punishable under both Section 19 and 14 of the National Drug Law Enforcement Agency Act. By the provision of Section 19 of the NDLEA Act, the maximum punishment prescribed by the law upon conviction is to be sentenced to imprisonment for 25 years, for a term not less than 15 years and not exceeding 25 years. However, having regard to the considerations which I had analyzed, the fact that the convict readily pleaded guilty to the charge immediately upon his arraignment, and of the fact that he appears remorseful, are factors which ought to inform the sentence which this court will pass. Although the quantity of the illicit drugs recovered from him is a considerable amount, which he goes about selling such illicit substances, as he stated to the court not too long ago, which betrayed him as a commercial dealer and not as a consumer, thereby endangering the society in general by such nefarious business or activities. In the final analysis, the convict is hereby sentenced to 12 months imprisonment for the first count, 12 months imprisonment for the second count for the offenses he has been convicted of, to commence from date of arrest. All sentences to go concurrently. This is to serve as punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. You are enjoying, essentially the essence of punishment is to obtain information in the subjects. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. The exhibit shall be returned to the office of NDLEA to be destroyed. The seized drugs being cannabis sativa, admitted as NDLEA Amadu 2, which weighed 2 kilograms, is hereby confiscated and shall be forfeited to the federal government of Nigeria, and shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by the representatives of the Nigerian Police Force, the Department of Security, State Security Services, and the Nigerian Security and Civil Defense Corps, as well as the print and electronic media, and the general public. This shall be the court sentence of the convict which has been handed down in order to this sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family. The convict may not be so lucky if in the future he's caught and charged for a similar offense. The convict has 90 days in which to appeal both the conviction and sentence if he's not satisfied with same.
Escort, please. My lord.
Escort, please.
My lord.
Yes.
My lord, count a year one, that will count 12 months. What of count one, my lord? Sorry, my lord.
12 months.
12 months. Thank you.
Yes, to commence from date of arrest. All sentences to go concurrently.
Okay. What two counters, my lord, is 12 months.
Yes.
Thank you, my lord.
You're welcome.
Thank you.
To commence, Mr. Salisu, to commence from date of arrest and the both counts to go, both sentences to go concurrently.
Okay, my lord, which date? Date for arrest. Date for arrest. Saboda haka ko da aka yi da halin da kai ci da kuma abin da aka samu wajen kayan yawan kayan da komai kuma hukuncin yana da yawa. Ta yi alfarma ta baka hukunci na wata 12 duka a tuhumar da aka yi ma. Sannan kuma ana so in ka gama wannan zama din da Allah in ka je ka zama mutum na gari a cikin al'umma. Yau kar ka kasance kuma mai ƙara aikata wani makamancin wannan laifin. Kuma kana da dama in ka ga hukuncin bai game ka ba za ka iya yin apil daga nan zuwa kwana 90. Amma dai abin da kotu ta faɗa ta ce hukuncin an sassauta ma sosai a cikin al'amarin.
Date of arrest was 16th day of July.
Thank you, my lord. Thank you very much, my lord.
Welcome. Yes, call the next case.
Judge number FSC/DM/CR/47/2023 between Federal Republic of Nigeria and Nura Garba.
Nura Garba. My lord, here at the Dependent in Correction Center. Nura Garba, president.
Yes. Sounds like you're muted.
Much going on, my lord. My name is Usman Bamala. My humble appearance is for the complainant. My lord, the matter is fixed today for review of facts of this case. Subject to the convenience of my lord, we are ready to proceed. My lord, we intend to review the fact of this case through the exhibit officer in person of Mr. Bagudu David, my lord. My lord, we apply Mr. Bagudu David to step forward.
The application granted. Yes.
Mr. Bagudu, affirm yourself.
I, Bagudu David, do solemnly affirm to state that the evidence I give in this case before this honorable court shall be the truth, the whole truth, nothing but the truth, so help me God.
Thank you very much. Please, once again.
You are muted, counsel. Yes. Your application was muted, so can you repeat the application, your submission?
Mr. Bagul David, please once again tell this honorable court your name and what do you do for a living?
My name is Bagudu David. I work with the National Law Enforcement Agency, Yobe State Command, my lord.
Yes.
Please, for how long have you been working with the agency?
It's about 12 years, my lord.
Tell this honorable court, for all these 12 years, what are your schedules of duties?
My schedule of duty are receiving suspect and the SCB recover from them.
Before he tells us his schedule of duties, what is the office first?
Pardon my lord, I didn't get.
Before telling us the schedule of duties, what is
Yes,
the office?
I'm an exhibit officer, my lord.
Exhibit officer.
Yes, my lord. You always still command, my lord.
Yes, then go ahead.
As an exhibit officer, tell this honorable. Continue.
My schedule of duty are receiving suspects and the SCB recover from them. Carry
Go
out a
ahead.
field.
Yes.
Carry out a field test and weigh of the exhibit recover from the suspect, my lord. Issuing exhibit form for suspect to sign. Arresting officer and witness officer, my lord. Testify in court when they need arise with the exhibit just my custody. Carry out A1 for forensic analysis in Lagos, my lord. Thank you.
Aikinsa shi ne gudanar da bincike akan abin da aka samu ake zargin, sannan kuma yana ɗaukar sample a tura don ƙwararru su gudanar da bincike a Lagos, shi ne aikinsa.
We can't hear you, counsel. You are muted.
Apologies, my lord. Mr. Bagul David.
Yes, my lord.
Please tell this honorable court, what do you know about the defendant in respect of this case?
My lord, on the 25th day of September 2023, the defendant was brought before me of two of the yellow officer, namely Awanu Musa and Mohammed Adamu, along with a black nylon bag, I asked the defender who owned the bag. He said to me, the bag belonged to him, my lord. I opened the bag. I opened the bag in the presence of the defender and the witness officer. I discovered that the wrap of dried wheat, wrapped in the white line of the cannabis sativa.
It was wrapped in
white nylon.
Yes.
I informed the defender I want to carry out a field test and the weighing of the exhibit. He said, I should go ahead, my lord.
Yes.
I carried out a field test and the weighing, and the test proved positive for cannabis sativa, weighing 800 grams, my lord. All was done in the presence of the defender and the witness officer, my lord.
Yes, go ahead.
Days later, I brought some exhibit form, namely certificates of test analysis, packing of substance form, request for scientific aid form.
Just a minute. Sorry, he needs to interpret.
Okay, I've got you, my lord. ya ce lokacin da bayan an same ka akwai wasu forms da aka bayar aka baka har ka sa hannu a ciki a can a ofishinsu, sannan kuma abin da aka samu wajen naka an naɗe shi da wata farar leda, shi abin da ake zargin naka a gaban hukuma yanzu.
Go ahead. Yes.
I filled the necessary column of the exhibit form. The arresting officer and the witness officer also filled their column, and the suspect printed on the form, my lord. I took one of the rounds.
Yes.
I took one of the wrap and put in the wire transported evidence form and seal it in the presence of the defendant and the arresting officer and the witness officer, my lord. Well, the remaining bulk of the exhibit, I kept it in the exhibit room for safekeeping, my lord.
Can you inform him?
Yes,
Interpret to him.
Oh, my lord, thank you. Ya ce akwai wata leda wanda a gabanka ake ɗiban sample, aka ɗebi sample aka sa a ciki aka